To rest or not to rest, Lori Vallow Daybell confirming to the judge this morning that she will not present any evidence to defend herself against the charge of murder conspiracy in the death of her fourth husband, Charles. Not one witness to call except herself. And at this point, the so-called doomsday mom will not testify. Her first trial coming to an end as we get set for closing arguments. I'm Justin Lum, and we are on the record. And just like that, we are getting ready for closing arguments and what could be the last day of trial. What could be a verdict coming in regarding the fate of Lori Vallow Daybell. Obviously, we know that she's serving life in prison for her crimes in Idaho, murdering her two youngest kids, JJ Vallow and Tylee Ryan. But as far as her fate in this case for the murder conspiracy charge and the death of Charles Vallow, now on a Zoom right now, we have Mel McDonald, a former judge for the Maricopa County Superior Court, former prosecutor for the Maricopa County Attorney's Office, and a former U.S. attorney in the District of Arizona. Now, Mel, we had some Zoom issues earlier, but so glad you could come on, and spontaneously, we're going to do this on the record episode right now, talking about what happened today. Jury instructions, very important. Talk about that for me as the jury gets a break for the weekend, but they are going to be instructed on some fine details when they get the case after closings.
You know, one of the most important parts of the judicial process are the jury instructions. As a defense attorney, and I was a defense attorney for 37 years, as well as a prosecutor and judge, one of the things you strive to accomplish is in the record to, if there's any question on the jury instructions, you raise an objection. You challenge the instructions wherever you can, because one of the most common reversals of convictions comes in erroneous jury instructions. I noticed today that there were very few objections from Lori, which again comes back to the basic premise. She's representing herself. She doesn't understand the importance of her record. She doesn't understand that every time she has a possible objection and misses that objection, she waives the objection, and therefore it cannot result in any benefit to her on appeal.
All right, now we want to get everyone to listen to this because we're all waiting to see if Lori Vallow Daybell would actually change her mind, testify, present evidence. Judge Boreski asked her again today. Obviously, the jury needed to be there for her to rest. She said she would rest yesterday. Today, she said again, she doesn't intend to testify or call any witnesses. Let's take a listen.
The state is present, the defense is present, the jury is not present. This is the time set to discuss the final jury instructions. Let me confirm with the defendant that, is it still your intention to not put on any evidence?
Right now, Your Honor, yes. As of this morning, I mean.
Well, do you anticipate that changing?
No.
All right. Because that does affect how these instructions will be read to the jury. So for now, we're assuming you're not putting on any evidence.
Mel, how do you gauge Lori Vallow Daybell's demeanor? Is she being truthful? I mean, you have to be truthful right in front of a judge, but the way she says she does not intend to present anything, but we're still waiting for this jury to come into the courtroom and hear her say she rests.
Yeah, I would be surprised if she were to, on Monday, announce that she wants to put on evidence. The only witness that she could put on is her own testimony. I don't think that is likely. Before, I thought there was maybe a 51% chance that she would testify. But I think the point has been well raised that she doesn't like other people to be in a position of controlling her, and a prosecutor would have her on cross-examination for days because there's so many holes that she's created in the case. So my thought is that it'll probably go to the jury with closing arguments on Monday. But if there's one person out there that might boggle that machine, it would be her. I think it's part of her gamesmanship mode.
Good point. Now, Special Projects Executive Producer George Obie here as well. I mean, we did not predict to be sitting here on April 17th ready to get into closing arguments. That's for sure.
No, and I think a lot of us were hoping and maybe even expecting Lori to put up some sort of defense. So then I have to question, and Mel, you can help maybe answer this. What does she have to do, and how careful does she have to be in her closing arguments to where it doesn't come off as a defense? And you know, with her inexperience in all of this, you know, it almost feels like a slippery slope. What are some of the things that she is going to have to be careful of and not say during her closing arguments?
You see, my belief is that I don't think she's losing an ounce of sleep if she crosses the line in a closing argument. I thought when she announced at the beginning of the questioning of the jury, or in her opening statement about not taking the witness stand, I think her thought is, and her plan would be, to try, even if it's improper, to get her statement in, her defense in, without giving the state the right cross-examine, which would result in the prosecutor objecting, the judge ordering the jury to disregard the testimony. But I think, to me, that makes the most sense, her not taking the stand, giving the prosecutor the chance to cross-examine her, and then being able, through her argument to the jury, because she's not a lawyer, to try to put in testimonial type evidence as a part of her argument.
Good point, Mel. I'd like to put you in different shoes. First, I want you to, if you're a juror, and yesterday she cross-examined Nate Duncan, and she sort of schooled him on Nephi and the different books of Mormon, and you are a member of the LDS Church. Just how does that come across to the jury as she's basically telling Duncan how this religion, is supposed to be presented, and how he has used Nephi in that story to basically make her look like she gave an order to kill in this conspiracy?
From day one, I think the representation of herself has been a catastrophic disaster to her. Any chance, which was small, that she had of influencing the jury or getting sympathy, I think she shot out the window. You often hear about in trials, there's a smoking gun here or there. In this case, there's been at least 4 or 5 smoking guns. I think the chilling text messages, her demeanor on the day of the killing, not calling 911 when she's packing a phone, going around with her children shopping, going in and buying sandals at a store, stopping for food, not reporting. Every one of these things, coupled with the jury every day seeing her demeanor, seeing that she is bright and articulate, I think what that does is a person has a better chance of winning the lotto than she does of getting an acquittal. I think it'll be a quick verdict. If she doesn't play the game on Monday and claim that she now wants to become a witness in the case, I think they'll probably be out by Monday afternoon, and I would be shocked if a jury wasn't back by Monday evening or at the latest Tuesday.
Okay, because they will hear closing arguments at 1 o'clock. So you think that the jury probably gets the case about 2 hours after that 1 o'clock? They'll get the jury instructions already in the morning. So do you think that this deliberation could be an hour or so, hour and a half?
I think it could be that. It may go over to a second day, to a Tuesday. If the jury gets it Monday by 3 o'clock, I think there'd be a very good chance that there'd be a verdict before 5. And I can see this jury not wanting to come back on Tuesday and going through that. mindful that there's been only 7 days of testimony. There's not a lot of witnesses, and the witnesses that were called had very specific points that they were brought in for. So there are probably 12 major points, I'm guessing, in the case, the different points that connect her to the conspiracy. There is zero sympathy, I think, for her, and the hypocrisy of some of her testimony, some of her cross-examination, the gal that had gone out with Charles the night before, her trying to ridicule her when she is having an affair with Chad Daybell. There are so many factors in this case, which I think has to have a powerful impact on this jury. And that's why I believe it's going to be a quick verdict.
Mel, for those that are unaware, from a judge's perspective, what will Boreski do? Will he get an indication from the foreman to find out where the jury is and whether or not he wants to keep them, say, past 4:30 or 5 on Monday, if there's any indication that they might be close? How does that work?
Typically what happens is they operate on a work day. When I was a Superior Court judge, we would generally go till 5. I would send the bailiff to the jury room. It's almost 5. Do you want to recess for the day? The jury then makes the decision, informs the bailiff. We want to continue to deliberate. Typically, the bailiff will let the jurors know, if you do stay, we can have food brought in, or you can go home for the day and return tomorrow. Oftentimes, if they're close to a decision, they're going to want to stay and complete the verdict so they don't have to come back the next day. I would suspect that's what would happen. The closing argument starting Monday morning, I see the prosecutor and Lori probably having their argument completed by 12:15 or 12:30. The state may have a short rebuttal in the afternoon. I don't know if they could put in the opening and the rebuttal in a 2-hour time frame, but then the jury's instructed and it goes to the jury. If the jury gets it by 2 o'clock or 2:30, I would not be at all surprised if a verdict is returned by 4:30 or 5. And probably at the latest, I don't see the jury going home if they're anyways close to a verdict.
Yeah, I was talking to Obi earlier about the 2023 Idaho trial. Jury got the case in the afternoon, but this was a heavy case, 6 weeks of testimony, probably 6 or 7 weeks, dozens of witnesses, and the jury basically had a dinner break, and then they went home, came back and deliberated fresh the next morning, and I think by noon or before noon, we had a verdict, and Lori Vallow Daybell was convicted on all counts. But there were like 7 charges. This is just one charge that they really have to go through instructions on. So it's a little bit different. But I think for this jury, everything is still so fresh to them, all of this evidence they've seen.
That's precisely the case. And I mean, I was a little bit shocked at how quickly the case went. I was anticipating it would be a couple of weeks. But quite frankly, Lori, again, representing herself, a lot of major witnesses, she doesn't have any questions. Those that she does question are fairly short questioning periods. And so the case has gone through rapidly. That's why I say the impact of the evidence with the multiple smoking guns, jurors in there's so many things that they can hang their hats on. And I've seen absolutely nothing. Probably the only argument I think that Lori has was, had there not been these post-crimes, the shooting of the niece's, shooting at the niece's husband, but especially the Idaho cases, when suddenly the focus is on it with Chad Daybell's wife passing away, I think that really put the heat on Chandler to really look at this. And the best part of the case for Lori is, had they not continued their crime spree, I think she may have had an opportunity or a chance of never being prosecuted for the murder of her husband.
What does she say in closing arguments? What is she going to do to get, one last shot to the jury to tell them that this was self-defense? How does she explain that one more time?
I don't know if it's possible to explain other than what little bit that we've seen from her, that the evidence shows Cox had a wound on the back of his neck. She was faced in a situation where her husband, a former minor league player, comes at people with the bat. He has an altercation with the daughter, or an argument with the daughter. I don't think there's much she can do, especially since she has no other evidence, that was the only position put before the jury. And I think she'll try to suggest, some of the questioning when she suggested steroid use and trying to put Mr. Vallow in the worst light possible. Here he's going out the night before with a woman, and the divorce hasn't even been filed. That's about all she has. And that's why I say her chances of anything, of acquittal, are the same odds as the lotto. And her chances of a hung jury are, I think, de minimis. I see it as a quick verdict.
And I don't want to look too far ahead, but obviously we know how unusual it is to have a defendant, high-profile defendant like this, represent themselves in one case. We know that it sounds like she's going to do the same in the next case, and these cases are coming almost back to back, a few week difference. They discussed it this morning. When you have dealt with cases like this, what are some of the things that have to be kept in mind when you have two cases as high profile as these are, this close together, and trying to find a jury? One of the challenges, obviously, is that they are, with the second trial, they're trying to get it done by the end of June. Is there anything that the public would need to know in trying to navigate making sure that both of these trials go on without any issues, without any chance of hurting a possible appeal?
I'm going to make a prediction here. I'm going to make a prediction that if she is convicted in this Vallow conspiracy to commit murder case, I'm going to predict that there's not going to be a second trial.
Wow.
And I'll tell you why I believe that is. She's already got life sentences in Idaho without the possibility of parole. There's a sound argument why the Vallow case goes forward this time. A person's life was taken, the cold, deliberate conspiracy to take his life. A conviction for this under the laws would be life with the possibility in 25 years. A judge, in doing the sentence, can have the sentence run consecutive. She's looking at 3 life sentences. Now, had the second case, had there been a killing, had he been severely injured with the bullet, I can see, because of the victim situation, that there would be sympathy. But from my days as United States Attorney, we would make calls all the time. There's no reason, in my view, to have the second case. She's never going to get out of prison again. It's going to be enormously expensive and time-consuming to have the second case. You don't have a victim that has been gunned down or dead. Fortunately, it was a close call. The information in that case helped the police in this case. I don't see any prosecutorial sense in going forward with the second case. So once they've got a conviction, I would be surprised if Rachel Mitchell and Trina Kay decide they're going to go forward with the second case. There's nothing more you can do to Lori Vallow than has already been done.
Yeah, I can see your point there. And people have said, hey, this is already a waste of taxpayer funds. And why is she doing this? It's a circus. It's a show. You see that, but you also see someone like the victim in the next case, Brandon Boudreaux, who survived this, and he wants In his mind, he wants justice for himself. He's the only surviving person, and he will be on the stand and get his chance to really face her, and she'll ask him questions if she does indeed enter this trial representing herself once again. And that will be a sight to see. But for the families of these people, Charles, for Brandon, they just want to see her get convicted, at least face justice in all of these cases that have intertwined and created such a bizarre saga.
One of the things that Brandon has, if and when she's convicted in this case, he would have an opportunity to address the court. The state can put on an aggravation hearing if they want to enhance the sentencing with the court. He would have the opportunity to speak. And yes, I can fully understand the feelings that are going through his mind. From a standpoint of people within the community, I think it would be a fascinating case, again, to watch. But from the practical standpoint, the effect on Lori Vallow, other than give her more time in front of the camera, so the jury can see her smiles and her actions, there's nothing to be gained by it other than the expense and pressure of a trial. She will have multiple conspiracy, conviction to commit murder, all of these other Idaho cases. She's never going to see the light of day. Mr. Boudreau will have an opportunity to address the court and make his pitch for the sentence in this case. So my thought would be for judicial economy and the fact that he wasn't hit with the bullet, that he has a chance to speak and know that evidence in this case also helped in the overall investigation. It doesn't make sense to me to go forward with this next case.
So if that were to happen, what is the likely scenario that they would work out a plea deal or just drop charges?
I don't think Lori's ever going to plead to anything. So the option would be move forward or drop charges. The choice would probably be a motion to dismiss. In the motion, the prosecutor could lay out a very compelling part of the motion, that she's been convicted of multiple heinous crimes in Idaho. She's been convicted of the conspiracy to commit murder in Arizona. She's looking at never getting out of prison for the remainder of her natural life. In the interest of justice and judicial economy, we move to dismiss this case. And that to me would make sense.
And then the final question is, does Lori Vallow Daybell file a response to that motion to dismiss? Let's not get too far ahead of ourselves, but wouldn't that be something? Because she does always have something to say. But I would assume that would be a win for her in her mind, that, that got dropped. Obviously, this is all hypothetical, but we shall see. Mel, the judge, thank you so much for your time. I'm glad we got things figured out on the Zoom end, and we're going to see you Monday for closing arguments.
That'll be great. Good talking to both of you.
All right, there it is. So 10:30, we expect everyone in court. 11, jurors report, jury instructions, lunch, 1 p.m. closing arguments. This whole day is going to be for closings. And then at some point, the jury gets the case to 12, the final 12. We don't know who that will be. And we will be on Verdict Watch. It's going to be great. It
will be great. We'll obviously have it live for you here on the stream, whether we can air the verdict live or we're still on a 30-minute delay. But either way, we will be here like we have been the last 2 weeks. Yeah. And we will definitely have a lot to say one way or the other. Yeah, it's going to be nonstop starting Monday morning. Yeah. So for all of you, subscribe, hit the bell. We'll see you on the record Monday.